Ladies and gentlemen, the Supreme Court has heard a deeply sensitive plea for passive euthanasia filed by the parents of a 31-year-old man who has been in a coma-like vegetative state for the past 12 or 13 years. The bench described the man's condition as extremely unfortunate and pitiable. The court noted that he is suffering from severe, painful bed sores, an indication, it said, that proper care and hygiene have not been maintained. The judges observed that when a patient in such a condition develops bed sores, it is often a sign of impending death. A medical team from the Noida District Hospital earlier informed the court that there is no hope for recovery. Doctors have said he is completely disabled, permanently bedridden, and will remain in this state for the rest of his life. Taking note of these findings, the Supreme Court has now moved to the second stage of India's passive euthanasia process, laid down in its landmark 2018 judgment and simplified in 2023. The bench has directed the director of AIIMS New Delhi to constitute a secondary medical board to examine the patient and submit its report by December 17th. The matter will be heard next on December 18th. The court said, "We will have to do something now. We can't allow him to live like this." It stressed that something urgently needs to be done given the patient's deteriorating state. The bench also reviewed a sealed report from the Chief Medical Officer of Ghaziabad, which again concludes that the recovery is impossible. Photographs submitted to the court show the man lying immobile, with tubes for respiration and feeding, and with extensive bed sores. Judges said the letter makes it clear that his condition is pathetic and that he has remained this way for nearly 13 years. This is the second time the parents have approached the Supreme Court seeking permission to withdraw life, sustaining treatment, and to allow their son to die with dignity. The broader legal backdrop is significant. In 2018, the Supreme Court recognized passive euthanasia and permitted living wills under strict safeguards. In 2023, it further simplified this framework to make the process workable, requiring clearance by primary and secondary medical boards, followed by judicial oversight. Across the country, implementation remains patchy. Karnataka recently became the first state to set up dedicated medical boards for withdrawal of life-sustaining therapy based on living wills, calling it a historic move to uphold the right to die with dignity. But most states still lack formal mechanisms, which is why many families continue to turn to courts in tragic cases like this one. For now, all eyes on the AIIMS board, whose medical assessment will determine the next step in this emotionally charged and ethically complex case. Passive euthanasia is a lawful withdrawal or withholding of life-sustaining treatment, allowing a terminally ill or irreversibly unconscious patient to die a natural death. It involves stopping treatments that artificially prolong life, like ventilator support, feeding tubes, life support mechanisms, and medications that maintain organ function. Eligible persons include terminally ill people with no chances of recovery, persons in a vegetative state or irreversible coma, persons who have lost decision-making capacity, persons who face prolonged suffering with no medical benefit from treatment. The process also enables giving a living will or advance medical directive, where an adult states what treatment they want or refuse conditions under which they want life support withdrawn. Who should take decisions for them if they cannot? This is activated only when the patient becomes incapable of decision making.